possession of marijuana for compassionate medical purposes. At that time, the village board adopted an ordinance that allowed for basically a 6-month moratorium for the village to study the issue and consider any appropriate amendments to the zoning code should the state enact legislation. The state subsequently did enact legislation. It became effective January 1st. The village moratorium took effect the same date as the state legislation took effect, so again January 1st of this year. Late in 2013, the Lake County Planning, Building, and Development Department reached out to all municipalities in the county as well as other interest groups to formulate what they call the task force or a study group to start to talk about these uses, what communities may be doing about them, what people thought, what law enforcement agencies thought, and so forth. And they came up with what might be termed as a model or an example framework of regulations that I believe they are about ready to adopt themselves for areas in unincorporated Lake County. Each municipality, however, must take a look at its own ordinances and adopt what it feels are the appropriate regulations in regard to both dispensaries, where a person would pick up a prescription, and also cultivation centers where the product would actually be grown. Last month, at the Planning and Zoning Commission meeting, really was the first initial discussion, kind of brainstorming session, a presentation from Mr. Savage from Ralph Campbell and Associates office, introducing the topic, discussing some of the ins and outs and nuances of the topic, with the understanding that this discussion would continue to this month, and then at some point in time, the Planning and Zoning Commission would need to consider or discuss about when to set a public hearing date to consider specific amendments to the zoning code. So tonight represents actually kind of the second discussion or second exchange of ideas before formally posting and going to public hearing whenever, again, that would be at the discretion of the commission as to when this particular matter would go to public hearing. I believe Mr. Savage is prepared to go over a series of draft regulations that were prepared between last month and this month. Again, this is all in discussion stages. It's all in idea stages, so nothing is certainly, set in stone, cast in concrete. This is all still discussion, evaluation, idea exchange. Again, with an eye toward maybe getting a handle on a time frame as to when the commission may want to go to public hearing. And with that, it may be appropriate at your discretion to hear from the consultant, or do you want to go into?
I think we need to hear from the consultant at this point.
I don't want to belabor anything tonight if the commission is worn out from the long Meyer presentation, but I can go over the items briefly or in depth as you may see fit.
Once over Brett, you can for the moment.
Okay, as was made before, I made the presentation last month, and there's quite a lively discussion at the commission level with respect to the two facilities and their potential location in the village. As we noted, cultivation centers probably will not ever occur under the current legislation due to the requirements for setbacks that have been set by the state for 2,500 feet from any zoned residential property. So a half-mile setback will eliminate them from the village presently. As we pointed out previously, going forward, it's most likely that these are going to get less restrictive at the state level, as they have done in every other state where this has become legal. So mainly we're focused on dispensaries. The language that's before you is primarily what has been generated by the task force. Highlight the main points that are not covered by the task force that are really more things that you will need to decide is, as we discussed before, if you're going to allow a dispensary, what district would the dispensary be potentially allowable in? That is your zoning district. As we noted, the state has stipulated you cannot prohibit these, either by special use prohibition or any way prohibiting them. We have provided examples of what the state setbacks are, and we noted that there are areas in town where primarily commercial districts. You could have your C2, your C2B, your C2A, some C3 areas. Presently, due to the setback, because of home child care facilities, your I districts are eliminated. But home child care facilities do change. Those aren't set in stone, unlike the schools and other potential setbacks that you could have. The second element that you would look at would be those setbacks if you would like to have additional setbacks for parks, forest preserves, places of worship, things of that nature. We gave you a map of what a 1,000-foot setback would look like, and it eliminates all but some slivers of your C3 and your C2B in the central part of the village. Potentially a couple of sites going forward. Just to highlight, it is not considered a prohibition if you designate an area that already has a building on it. That is considered a market problem. The courts will, and the legal counsel, if they want to chime in, has always said if it's a market problem, the market gets to solve it. It's not your responsibility to let you give it a place to have a location. That's just economics.
We went through this a number of years ago when we were looking at adult entertainment sites and discovered very quickly that you were not allowed to legislate them out by what you specified for setback. My feeling is they should be allowed in C2, C2B, C3. But setbacks, separations from specific other uses could be incorporated. My understanding of the dispensary facility is that basically what you're talking about amounts to, and you should pardon the expression, a drugstore. It's not much different from having a Walgreens or a CVS pharmacy.
With some exceptions, Chairman, in the fact that you do not have to have a pharmacist on staff, and it will service a population of 214,000 people. So it's a little larger than your CVS. Yes.
Yeah, but basically it's the same type of function.
Potentially, yes.
And the only thing there's only two issues that I see that need to be added in, and one is a restriction on approach distance to specific uses and setting it up so that you don't have to worry about what happens if somebody on an adjacent property decides to put in something perfectly legal, but that now interferes with a setback.
That actually, that's their choice. They can't legislate it out by putting something closer or trying to do that. So that goes for any use. You can, like liquor license, it has 100 foot. You can't put something, or it has 100 feet. You can't get any closer just and try and get rid of liquor store.
Yeah. But
By a new use. The new use can't get rid of it.
okay,
By law.
so that one's covered then.
And actually, I think in this statute, which is about this thick, I think they actually covered that.
Yes, it only applies to pre-existing.
Yeah, I think they actually addressed that.
So first in gets rights of location.
Exactly, I think that.
The other locational issues that we raised at the last meeting, Chairman, were the fact that these are cash-only businesses presently. So security is a major concern, and having a facility to be able to drive in a vehicle to load in cash as well as unload pharmaceutical products in a safe, secure location.
Since the last meeting, the federal government has changed the legislation to allow banks
Yeah, it has not changed social season.
to deal with, they're not.
No, they haven't changed the
Penalized.
legislation.
They haven't changed it.
Well, they've
They
gone
They
through
decided
some.
not to enforce the existing legislation.
Right, there you go.
Which can be changed again with the stroke of a pen. For the moment, we need to treat it as what the law says it would be, which is a cash-only business. And yeah, there is potential risk there, but on the other hand, there's potential risk for banks too, and they deal with them. as far as a cultivation facility, I think the only place we could put those would, if we were going to allow them, would be in the industrial areas, the I-1 and the I-2. Where else are you gonna get enough space and setback for it?
That's true. They're all have to be indoors, so they have to be large, expansive buildings, and have also the electricity capability of having the grow lights as well as the water capabilities of growing hydroponically.
Right. Yes, exactly. The only place we've got that kind of space, where if we've got it, would be in our industrial zones.
Or a former Walmart store.
I think somebody beat you to it.
Former Kmart. Good. Oh, wait, you want to read that one? Other than those things, the other one that we have suggested outside the task force is a standard for parking. For the most part, it's going to leave up the parking standard, just as we discussed tonight with the Meyer store, to whatever the developer proves that he can and need. Basically, we're setting a minimum of 100 spaces. These are monopolies. A dispensary will be a monopoly for a service area of 214,000 people. There's no real study on impact for traffic yet. There's nothing out there that says this is what it's going to be. Just doing a brief cursory range of cars, it could be anywhere between 30 to 400 per hour.
You're really going to have to educate me. How'd they arrive at 214,000? There's 60 licenses that are going to be issued, and per capita that comes out to 214,000 for the state of Illinois. It's going to be 3 in Lake County, so Lake County has roughly 700,000 people. Working backwards are somewhere in that range of 200 people. But per capita, Illinois, yeah, so.
And then we already have one in Lake Zurich and Zion.
Yeah.
So I think there's one more available.
But no, there's none that have been approved or going forward yet. And the one in Zion was for a cultivation center,
Oh,
and it's been retracted.
Okay. Well, I have a question for you. For the residential area on page 3, item B, I think it should be the same distance as churches and parks or anything else, because I'm, a residence, I think it should be as far back as possible. And I know 1,000 feet is a pretty good distance, but,
And that's something that you as a board, we're going to need to discuss back and forth. I will say 1,000 feet will eliminate everywhere in your village. We went through another village discussion, lengthy, and one commissioner was very adamant that it had to be the same. And the other commissioners said 500 feet to provide some room. It is something that you at this board are going to need to make the decision on what that needs to be. And then also in the coordination with legal counsel, whether that's legally allowable in terms of prohibition.
If we were prepared to allow adult entertainment facilities within 500 feet, I think we should be prepared to allow this sort of thing within 500 feet. The school daycare 1,000 feet doesn't bother me, but just for the zonings.
the only thing I'm thinking of from a neighborhood standpoint is you're saying it's a cash-only business and just the potential crime.
The security concerns are the main issue of the dispensary, as we discussed, is
And
how
that's
it functions, and it's unique. It's not, as we discussed before, it's not something you've ever dealt with before, and no one really has a book on. And the way they're designed in Illinois is different than the other states.
And that's why on page 5 it says drive-through should not be acceptable. I think it should be acceptable.
I will say that the state is presently proposing in the rules that they're not going to allow drive-throughs.
So it's the state that's mandating.
Right now, in their draft rules, so there's the legislation and then the rules that they're going to have to apply to through the Department of Financial Professional Regulations, which is a stack that big, and one of the things they are prohibiting is drive-throughs.
That's a shame, because the people who are potentially purchasing this may have a problem walking and getting into the facility, and for their safety concerns, they would probably appreciate the drive.
Audrey,
I'm sorry.
for marijuana, substitute alcohol. And and tell me you want to drive through.
Going for whatever we have.
Yeah,
But this is a medical.
I
this is
understand.
medical purpose.
but somebody picks it up at the drive-through
They're gonna have
and they're
fun.
lighting up on the way out.
No,
They-
no,
You
no,
know,
no.
that may change too, but it may initially be, they're not gonna have a lot of change, I don't think, to the draft rules, because they wanna put it in place as to what staff's recommending, and so eventually they may allow drive-throughs in the future. But I can't imagine that they're gonna make a lot of changes. They're in the comments time for another 3 weeks, right? It's to the end of March.
They're proposing for April.
Oh, it's
Sometime-
April?
April was their kind of deadline,
Okay.
sometime in April, I don't know the hard date.
Okay, let me go back to something you said earlier. If we used 1,000 feet for item B, there would still be property available
There would
that
be,
would support a dispensary?
there would be no properties available in the village, with 1,000 feet and the other setbacks,
Okay.
which would be parks.
If we set, the setback would be at 500 feet, there would be parcels that would be suitable for a dispensary if they wanted to build on it and have ownership of it.
We would have to look at that a little further. I think it may be close, with respect to the few areas along Rollins in your C2B area next to, the assisted living facility. In that area, there might be 1 or 2 areas left, but it's still gonna be very close with the 500. But we were gonna review, that standard next with respect to whatever the commission wants to see, if it wants to see a residential setback.
Based on previous experience, we cannot put the setbacks at such a number as to eliminate the possibility of finding a spot to put a dispensary. I think that the number should probably be chosen to be as large as it can be without creating a total blackout. As you said, it doesn't have to be a property that's available, it just has to be suitable.
This is a little bit different than that, because this is a statutory creation, and the adult entertainment impacted a constitutional right, a fundamental right under the First Amendment of free expression, if you believe the Supreme Court of the United States. So, if...
I like the way you phrase that.
Well, I don't know that those uses aren't really First Amendment uses, but this is something that, it's difficult to say, but there's other towns in the county that they can go to, or unincorporated areas of the county, and they would have to show some type of compelling need to be in the village of Round Lake Beach, when there's only, at this point, 3 licenses available for all of the county. So, I don't know the answer to that question right now. We haven't really been asked it. It is, what if we set the setbacks at what we think is reasonable and it legislates this use out? We would have to look at that.
And my feeling on it is, and this is an opinion, okay? If we set it so that there is at least one property that could be available, then we don't have to worry about somebody coming in and threatening to sue the village because we have blocked out what is otherwise a legal use. Now, I understand what you're saying about the adult entertainment being a constitutional right of free speech, but we've been through this many times with our ordinances about permitted uses, about special uses. If you block out a use completely, I think you leave yourself open to someone challenging you because there is legislation that says this is an allowable use within the state. And then you're blocking it out completely. Whereas if you leave space where they could do it, not necessarily available for them, but it could be done if they were willing to pay
Well,
for it.
and that's what we have to look at, because there's, you have prohibited uses under your zoning ordinance.
Right.
So, and of otherwise legal uses that the village just says you can't do. So we have to look at the ordinance, the statute, and as to how it's raised and what measure of control that we can impose, and I haven't done that yet.
If we are allowed to say, to set this up so that we can block it out, I don't have a problem with that. What I don't want to do is set us up for having our foot stuck in the trap.
Yeah, I don't know that somebody is necessarily going to litigate for it for the reason that there are only a few and there's other places to go. What I would say is, why don't we look at it with regard to inclusion rather than exclusion, and then see what we can come up with along with Jeremiah and John.
I will just reiterate, as council, this is gray as gray can be.
Yeah.
You won't rely on my 8th grade civics class to talk about federalism and the federal government saying it's illegal and the state government saying it's legal, and who has jurisprudence over that. I also say that the people in charge of dispensaries at the state level for enforcing it are the Department of Financial and Professional Regulations. They're not land use people at all. So looking at zoning is going to be completely new for them even, so.
Oh, don't I know it?
Yes.
I have to deal with those silly people too.
So this is a whole new ballgame for them even to be getting into something where they have to look at a land use standard at your level, so.
The problem is, when you do that, you sometimes get some very silly results. I think our legal counsel has the right idea. Let's take a look at it and see what seems to work best.
Would we be able to turn around and say, could we do something like saying that C2, C2A, and C2B, that would be, to be restricted to that area? And say, okay, this is
That we can do
Yes.
easily.
Yes, really as far as the districts, I think everyone, I think those make sense. What Mark was saying and what Jeremiah was saying is looking at the commercial districts only and then the industrial districts for the cultivation center. And there's only 2 cultivation centers in the whole county that are available, and there's a lot of places that are excluded already by the statute just because of the 2,500 square foot or 2,500 foot distance, countywide. So if we can look at really what it comes down to is, should there be an additional setback for the land use and what's reasonable so that one could locate here conceivably, right?
Yes.
That's where we're going. Yeah.
We don't have to encourage them, but I hesitate to do an absolute block by this method.
Yeah.
If there were another way of doing it, it probably wouldn't be a bad thing. Not that I object to the concept of medical marijuana, it's just all of the fringes that come with it as it's currently set up, because of the fact it's cash only and there's so few licenses and so many people. And it's going to be worse than that because there's going to be what they're doing in some of the other states where they're no longer limiting it to medical, they're also going to recreational. And at that point, we really need to look at it hard. Did I give you sufficient guidance for the moment?
That provides us with the direction that we can review further those setbacks with John as well as legal counsel on coming up with a number that may work for these setbacks and letting you guys hash it out some more. As I said, this was lively discussed before and is lively discussed tonight, so there's not going to be one set answer, I don't think, from any person. So
Ideally, I'd love to see it located within a medical, facility building. And I know that would be under private ownership and they'd have to accept that. But, the people in the parking lot wouldn't know that you're going in there, to buy medical marijuana. You could be going in for a doctor's appointment. So for a safety standpoint, it might be a little bit more concealed as, your business, what you're doing. And it might be a little safer for the person purchasing.
Ideally, that would be the situation.
And I know that we
Sadly,
can't control that
this state has
situation.
set it up so we can't explicitly do that, and the fact that the FDA hasn't approved this, it
And,
creates all those issues with somebody that's a medical professional wanting to handle this at all.
but at that point, I wouldn't worry as much about the setback if it was in a more controlled type of environment and wasn't a standalone type business.
I think most people would agree if it was being handled by medical professionals only in a medical setting, for medical purely purposes, I think everybody would agree that this was a pharmaceutical. And not getting off to something that we don't know what it is, you know, it's truly a medical use.
And another thing I didn't notice as part of the proposal, there's a lot of places now that are restricting firearms as far as bringing it into the facility. I didn't notice in that proposal that we're restricting firearms bringing it into the facility, and I would assume that that would be something that we would not allow.
We can add that. I
Yeah,
think
you
it's
know,
the same.
actually, we can't. There's a prohibition on that, and if it's not expressly included in the Concealed Carry Act, which you would have thought, somebody would have thought of that, the individual business can post a little sign and say no firearms.
So it's at their discretion, we can't regulate.
Right, we don't have the authority to say you can't do it. There's a specific preemption as to local control of concealed carry. So they should have been thought of because they're being debated at the same time as to how they were going to work together, but apparently the legislature was not thinking that.
You're assuming the legislature can think.
Oh, right. I mean, they were both flowing through the House, or through the state legislature at the same time. So that they should have been some interface unless they just didn't want to deal with it.
I think there might be something in the draft rules, I don't remember off the top of my head, though, if there or not.
Yeah, there should be, the individual businesses, I'm sure, would prohibit, but I haven't looked at the rules. Somebody in my office printed them off and did them too big.
I'm sure from a business standpoint, it would behoove them to.
There's gonna be you're gonna start seeing a lot more of those now that concealed carry permits are
Yeah.
coming out. A lot of
But
stores.
they wouldn't want people walking out the door with firearms, that
No.
opens them up for robbery, so
Right, exactly.
they're gonna regulate that.
Yeah, I think it's common sense that they're gonna do that on their own, any of these licensees. So, but unfortunately, the village doesn't have that control.
I think we're giving you your direction.
There was a point that I wanted to make.
Nate?
The whole concept, the attitude that I'm getting from most of this is that we want to try and discourage it. I want to look at it the other way. If you think about how many people are going to be coming into the village and the type of business that we're going to get out of these people, they're here, they might, once they pick up their prescriptions or on their way here, do more shopping, spend more money in the village. It'll bring more people to the village. I think it might be a good idea to encourage somebody to come here.
Sure, they'll have the munchies stop off at McDonald's.
That's right. If we put it right down the street from
I
New
think-
Meyer, they'll be
No,
in there all
we're
the
looking
time.
at inclusion. I think that's the, I mean, the setbacks and stuff are good for, you know, establishing standards like the county task force has come up with. I think these are all good things, and the final piece of the puzzle really is should there be a setback for some of these uses like the schools, which is, and parks, which is a liquor license thing. So I think that we're gonna look at that with an eye towards including them and allowing them, rather than excluding them. So the other requirements, you know, including landscaping and parking setbacks, a lot of that stuff is gonna already be in your ordinance relative to development, say in the C2B district. You're gonna have things or a special use where we're gonna have some enhanced look by staff and by this commission often. So I think this kind of a belt and suspenders type approach to it.
Well, I agree with Mr. Bailey on the whole idea of it being a pharmacy. Basically what it is. Other than the cash-only option, which I'm pretty sure they're gonna change it really quick. I watched a show on CNN about this, and they had talked about the federal government's working on legislation to allow them to use banks, but most of the banks are reluctant because they're still open for prosecution through the federal government.
They've only come up with Department of Justice guidelines, and it only goes as far as the administration stays in power. It's going to take the watershed change at the federal level before the banks really get involved with this, because it's not just the feds going after them, it's civil interests going after them for allowing something, promoting something that's federally illegal, even though there's guidelines on paper only. Is that coming in the future? I believe yes.
Yeah.
You know, but it'll be a watershed moment, you know, it'll be something, but it's still, right now, Illinois, everybody's unique, and Illinois is unique again with the way they've set up with the monopoly licenses. So that's a concern that you gotta look at for now. And as we kind of talked before, is you can always pull back. This is just your first go around, and then you can pull back from it, you know, to make it more or less restrictive in the future.
There's also the fact that because it's being done in some other states, it may be possible to get some information that would allow us to look at things like parking space requirements and traffic patterns through and refine that a little bit.
I looked at, the most comparable one is Michigan, and only Ann Arbor had set a standard for dispensaries. They did not have a prohibition on monopoly. And the new states are all coming out with monopoly license system, similar to Illinois, so there'll be a lot more information probably in a year. But California, it's wide open, you know, as long as you can meet the requirements. They have setbacks and things like that. Colorado, as we know, is even more wide open than Seattle. So the ones that have been in there a while, I looked, they didn't have anything that's really great yet. I would say in a year, yeah, there's going to be some planning and zoning article in some magazine that says it's 4 per 1,000 or 5 per 1,000, and we're good to go. But it's the limitation right now that it's creating this big area that's, I will tell you, I bet Meyer has a draw of a population of about the same amount of people. What they're looking for. Home Depot is usually around 50,000. I remember their number that they want to get a whole population draw. So I can imagine a Meyer's probably 4 times that. So it's unique to say the least.
Anyhow, have you got enough guideline to keep going?
Yes.
Okay, anyone else want to contribute to this one? Anyone from the public want to make any comment about anything that belongs before the planning commission? In that case, I'll entertain a motion to adjourn.
So moved.
Second?